Get ready for the dictation in 3, 2, 1, start. The plaintiffs filed the present suit for permanent injunction restraining infringement of copyright, unauthorized downloading, misappropriation, and illegal use of database, delivery up, rendition of accounts, damages, and for passing off. Stop. Plaintiff is a registered public charitable trust founded on 16/10/1993. Stop. The plaintiff trust conducts research in human rights violations and abuses worldwide and in a particular South Asia with a view to disseminating the result of the research for the benefit of the general public and the international institutions and community to undertake research and publication of educational material on human rights. Stop. It is the case of plaintiff that to execute and advance the above objects of the plaintiff trust. Stop. The plaintiffs incorporated and established a private limited company by the name of South Asia Human Rights Documentation Center Private Limited as a wholly private owned private company for carrying out research, documentation, and reporting on human rights issues. Stop. It is alleged that the trustees of the plaintiff were the promoters of the company and subscribed to the share capital of the company. Stop. The plaintiff categorically stated that whatever work is carried by the company is done and executed for and on behalf of the plaintiff trust. Stop. The plaintiffs and the South Asia Human Rights Documentation Center Private Limited is the joint and several owners of the copyright in the literary works produced under the aegis of the South Asia Human Rights Documentation Center Private Limited. Stop. It is asserted that the company is wholly owned and controlled by the plaintiff trust and the trust has the right over all the material produced by it. Stop. The suit was filed on 15th May 2006 and an ex parte injunction was granted in favor of the plaintiffs. Stop. Written statement was filed by the defendants wherein they raised several preliminary objections to the suit. Stop. One of the objections taken by the defendants was that the plaintiffs were not the owners of the copyright and that the copyright belonged to the company and as such the suit was not maintainable. Stop. The replication to both the written statement was filed by the plaintiffs. Stop. Para. On the basis of pleadings of the parties, issues were framed in the suit. Stop. The plaintiff sought condonation on the ground that the drafting counsel of the plaintiffs was out of station for several days for personal reasons and the application could not be prepared and filed in time as the plaintiffs could not avail legal help for some time. Stop. The delay is neither malified nor callous and the application is formal in nature. Stop. Moreover, the delay has not caused any prejudice to the defendants nor has it delayed the process of court. Stop. The defendants have raised various objections in allowing the present application on the ground that wide order dated 27/11/2008, this court permitted the plaintiffs to prefer the application within 3 weeks. However, the said application has been filed 46 days after the expiry of 3 weeks granted by the court. Stop. The learned counsel for the defendants argued that it is deliberate act on the part of the plaintiff to delay the matter on one pretext or the other. Stop. After considering the submissions of the parties, I am of the considered view that the present application be allowed, as the plaintiff has been able to assign sufficient reasons in the application for condonation of delay. Stop. Thus, in the interest of justice, equity, and fair play, that the application filed by the plaintiff is allowed. Stop. The plaintiffs prayed that since the suit is in the preliminary stage, the company shall be impleaded as co-plaintiff to the suit to obviate all technical objections. Stop. Thank you.